This is a continuation of Chapter 7. We're talking about human rights, a little bit about NGOs, and a little bit more about the International Criminal Court. So let's talk about human rights. The sources of human rights are fairly similar to what we talked about with international law. Religion, this can be in somewhat of a chronological order. Early on, religion was a very important source of human rights in that all people are endowed by their creator with certain unalienable rights. And then that progressed over time into natural law, that as man in state of nature has rights to life, liberty, property, happiness, things like that, which were also part of the liberalism influence in Western societies. And then we also see that, as with international law, which we talked about earlier as the positivist viewpoint, we see that over time, societies evolve into norms of human rights through customs and practice, particularly of what that society wants or needs, or in fact decides on how it wants to treat its citizens. Two basic approaches toward human rights. The universalist approach is that all humans possess the same rights, so therefore all citizens in all societies are generally afforded the same rights of life, liberty, things like that. The relativist view tends to deviate from that to a degree, in that the rights are a product of that particular society's contemporary values and changing social norms. Those norms could be converging, but they are most likely different from one society to the next. So whether or not they're evolving or shifting or changing, the relativist view would look at, well, those are the rights in that society based on how they've been socialized in that culture. The death penalty, for example, provides a way to kind of clarify these two approaches. The universalists would see that the death penalty is not effective in general and looking at it as far as being abolished worldwide, whereas the relativists would see that the death penalty is kind of dependent on the cultural beliefs of that particular society. The United States, for example, is a more punitive society and still has a majority that favors the death penalty. Here's a global map of the death penalty, for example, where you see the states in red, which includes the United States, retains the death. Now, effectively, there's only about a handful of countries in the world that do the vast majority of executions in the world, and that would be China, Iran, Saudi Arabia, and the United States in particular. Some states are not doing the death penalty in practice, just have stopped doing it. There are a few states that are abolitionist, except in extreme cases, and then the green states have abolished it outright. As far as defining human rights, this kind of falls in line with our definitions of freedoms that we talked about earlier with the Freedom House measurements. We've got civil political rights, which includes freedoms such as speech, religion, due process of law, habeas corpus, that we've touched on, and the economic social rights, which guarantees certain living standards such as health, security, education. And here's an interesting distinction. The United States is very strong in these types of rights here, particularly guarantees from the government or protections from the government, whereas the United States is not quite as favorable towards guaranteeing these types of rights, such as health, because our healthcare system is still a private system. And even though we do have public education, Yeah, college costs quite a bit. And the United States has been socialized over many generations to where the individual is tasked with doing a lot of things based on their own efforts. And so, therefore, not quite as favorable towards having these types of things guaranteed for every person, although it is potentially changing because we do see that universal healthcare systems are becoming a little bit more favorable, even in the United States. This is the map that actually came from an earlier discussion we had about Freedom House, is where they are using those particular measures to determine how free or not free a country is, whereas the democratic states typically are ranked as free, and we've got several states that are ranked not free, typically the authoritarian states such as China and Saudi Arabia. The basic institutions of human rights in the modern era have their foundations with the UN's 1948 Universal Declaration of Human Rights. And you can look at that up very quickly and read that uh, very fairly quickly because it talks about very basic rights of human being to be able to live freely on this earth, certain expected or hoped for norms of behavior, life, liberty, security, law, even concept of presumed innocent until proven guilty, things like that. So that's a fairly broad foundation of human rights that all states typically agree on because all states are members of the United Nations. And then we see in the book there's a progression of 7 major treaties that have addressed certain areas of human rights, whether it's for women or children, things like that. And these are considered legally binding contracts. And you'll see in that table that the United States has not ratified a few of those. And what stands out among those is that those are typically types of treaties that are guaranteeing more of what we call the economic social rights, which the United States is not quite as favorable towards guaranteeing because we live in a more individualist society and we put a little bit more, I guess, onus on the individual to achieve those certain things rather than them being guaranteed by the government. So you can see that interesting distinction in that table in the book. And as we talked about with international law, all of these treaties have the same problem of enforcement. Yes, states agree and sign these treaties and ratify them for a reason, and states generally try to keep their commitments in order to maintain their credibility and attract, if they agree with this in the first place and feel like the world would be a better place by everybody agreeing with this, well, then there's obviously motivation to maintain it and commit to it. But if somebody cheats or backslides on that, it's a very difficult problem of enforcing them to keep up with what they had committed to doing. As far as addressing human rights abuses, we've talked a little bit about sanctions already. Those are typically the first go to actions by states that are coming together to try to punish a violator state. As we'll see, sanctions are problematic unless you have everybody involved so that they can be maximal and swift to try to punish that state as quickly as possible to get them to turn around their behavior. There have been some successful examples of that. We've touched on a few, such as with Iran, that eventually we got Russia and China on board with those sanctions to get Iran to the table as far as the nuclear agreement. Of course, that was torn up under the Trump administration. We also see that sanctions have a tendency to hurt the citizens that are most in need, and if sanctions prolong, it could be have harmful economic effects and social effects to their citizens of that country. Another thing that states might do is just symbolically try to name the violators and shame them, and might have the court of public opinion and pressure, international pressure, that might keep states from continuing their abuses. The UN has pursued this in several cases. In 2005, there was even a resolution that was passed called the Responsibility to Protect. The intent of this was all the states that were member of this would then come together and rally around and behind, and get behind a state, or try to come to the aid of a state that had large scale abuses. Of course, the problem with this is getting everybody to buy in on that, and that what would have to happen to get all the states to come together and work against that particular abuse. And the idea that the international community would act for humanitarian intervention is a tall order, that most states are going to get involved in an interaction or an intervention because it's rational for them to do so. It's in their interest to get involved in that. And if it's just because we need to help other human beings that are being abused, that's more difficult to justify doing that. So that's, again, that would require long standing shifting of norms as to everybody coming together on the same page and agreeing that this is what we want to prevent from happening, regardless of whether or not it's your state's self-interest or not. Now let's talk about some basic barriers or obstacles to progress on human rights in the world. Sovereignty being kind of the underlying factor here. Now we've got to be careful with using sovereignty as our go-to answer. Just like with the international law, we can say what makes international law difficult. We can say, oh, sovereignty. Be careful. We don't want to use that as just the blanket excuse. Sovereignty is the definition of sovereignty is that states are that are their own autonomous decision makers. It's therefore then still their decision whether or not they want to comply with certain things or not. So we've got to be careful with using that as a standard go-to pat answer. But sovereignty enables, in a way, states to keep the abuses within their borders. We've talked about this before. This is my business. You take care of your business, I'll take care of my business. And therefore, other states are not inclined to intervene if it's not in their interest to do that. They might call them out on that, or perhaps even do some sanctions in order to perhaps get their attention, but not necessarily inclined to get into their business. Iraq, for example, signed both of those treaties that were in that table that we looked at as far as political rights and economic social rights, and then turned around and abused it with Saddam Hussein in control there, using that cloak of sovereignty. Nationalism is another barrier to human rights, because when people start to become more nationalist leaning, we start to see more of a we they complex, an us versus them complex. And so that becomes less and less. We got to worry about our own selves. So there's less of a responsibility for others, less sense of responsibility for they. The relativist view of cultural standards is another potential barrier to progress on human rights, because if the relativist view prevails, then that would say, well, that's how they do things there. So that's their business. We're not going to worry too much about that. Maybe international pressure will get them to subside on that and start converging with the rest of the world, that sort of thing. Political selectivity is done by all states. The United States provides a couple of examples as to where we may promote democracy amongst ourselves, and the United States might actually be declining a little bit as far as promoting democracy worldwide. But the bottom line, even though we are a democratic state and promote and highly value democracy, the United States does still support various authoritarian regimes when it is in our rational interest to do so. Could also say that it is fairly practical for us to cooperate with states that provide enormous economic benefits, such as China and Saudi Arabia, despite them being authoritarian regimes. We've also seen that the United States, like many other countries, has contradicted themselves in some cases where in the war on terror, it's been we've been reined back in as far as the abuses that kind of got out of hand. In the war on terror was the Abu Ghraib prison scandal, where the prisoners were systematically abused. The the Guantanamo Bay situation, where terrorist detainees were held for many years without any representation, and then when we rendition or outsource our interrogation that could lead to contracting out of torture and waterboarding and things like that in order to try to get information, well, then that is kind of a double standard where the United States is, getting into some of these human rights abuses as well, and then at some point figures out, well, that's not really the route we want to go, and then rein ourselves back in. And low priority is one thing that we've mentioned already, is that human rights is something that is more easily delegated out to international organizations. We need to deal with China for economic business. We need to deal with this country or that country, even though we do not agree with their human rights record. So that's a lower priority, and we can push that off to the side or delegate it to an IO. So those are some very prominent barriers to human rights becoming even more of a converging global norm. Just a quick word on non governmental organizations. These are set up by private individuals, they operate across borders, and these are membership of non state actors, whereas the IOs are put together by the states. The states rationally need them for their benefit or to promote cooperation. These are groups put together in order to try to do what states are unable to do. There's many different NGOs for many different causes, such as monitoring the human rights abuses that we've been talking about, or looking at environmental issues, or women's rights, things like that. And over the past couple of decades, with the increase in transportation technology and communication technology, we've seen a massive influx of non governmental organizations that are trying to work at grassroots levels to a certain extent. They rely on voluntary cooperations. Typically, they're nonprofit organizations that need volunteer contributions. And they can also get grants and subsidies and aid from states as well. But they are trying to help people who are not getting help from their state. Could be refugees, immigrants, people like that. And typically, what NGOs are reflecting is this disenchantment with the inability of any particular state's governments to solve their problems. So, need some help from outside coming in, NGOs providing some of that. Lots of examples, business related, NGOs, politically related, such as Amnesty International and Human Rights Watch, two of the more prominent ones. The International Olympic Committee is an example of an NGO that's come together for states to compete on the athletic field. International Red Cross has got some very prominent advantages, or I guess you could say exemptions, in any type of crisis where states are obligated to recognize International Red Cross to be able to get in there and help people that are in need. The religious aspect, the Catholic Church, despite the problems that they have had here and there over the past couple of few decades, they are still a very prominent NGO providing lots of aid all over the world. Now let's talk about The International Criminal Court, another specific example of an international law focusing here on human rights abuses. It was established through the United Nations. The United Nations set up a convention, and in 1998, it's called the Rome Treaty, was signed. It was entered into force into 2002 once 60 states had ratified it. To this date, 123 states have ratified it. The United States and Russia have not ratified it. We'll talk about some of the primary reasons as to why the United States has not. China, India, Israel, just as a few examples, did not sign it in the first place. So, what we're seeing is some of the same problems here with international law. It's a matter of compliance. And if the states do not want to be a part of this criminal justice system, then they are going to opt out of it. And generally, the United States is worried about putting its ground troops at risk of being prosecuted by the International Criminal Court. United States being the biggest military power by far and has troops and diplomatic personnel in over 140 states in the world. That puts them a little bit more at risk if something goes wrong in that country. Now, we could ask ourselves that is it unlikely that the International Criminal Court would want to spend time and effort on foot soldiers that make a mistake? Not likely. But as we'll see in a minute, if there is some sort of systematic abuse from the top down, yes, could be likely to be subject to at least investigation, if not prosecution. And so that's what typically has kept the United States out of the ICC jurisdiction because of their more exposed risk all around the world. Here's the map showing the state parties to the ICC. The states in green are member states that signed it and ratified it by their own legislatures. The yellow states are the states that did sign it initially, such as Russia and the United States, but they did not ratify it. George W. Bush, back in 2002, did not even submit it to the Senate. It was signed under the Clinton administration. Otherwise, it's quite possible that it might not have been signed. Now, the red states are the states such as India and China that did not sign it in the first place. You've got a total of 123 states that are member states, so that's a majority of states, but that, of course, still means it's got a ways to go to have a comprehensive legal system in this case. Types of cases or the abuses that are pursued by the International Criminal Court are four major categories: war crimes, which is violations against laws of war. And prior to this, the United Nations Security Council had established tribunals to take care of this. In the case of former Yugoslavia, where the Bosnian War broke out, Rwanda, where we've talked about that horrific violence that flare up there, Sierra Leone, which had a couple of decades worth of civil war there. Also, crimes against humanity. An example of that would be the Nuremberg trials on Nazi atrocities, and convicted several former Nazi leaders to death. Genocide, and that's the extermination of an ethnic group. And then this last one here is the one that concerns the United States in particular, is what we call the crime or war of aggression that is in the process of adoption. And in this case, because the United States, being a strong military force that has intervened over the years in cases, particularly with non-democracies, well, if something comes up to where the international system feels like the United States pursued that aggressively, yes, they could be subject to investigation on that. So that's yet another reason as to why the United States is not part of the International Criminal Court system. Now, what makes the International Criminal Court different? It's not quite the same as a typical prosecuting attorney's office that you would have in uh, in the state of New Jersey, New York, something like that. The ICC, based on its charter and what the states that originally approved and ratified it, is that it has universal jurisdiction. It potentially has the ability to prosecute individuals of any state. So, literally, what we're seeing here is that the point of the ICC that makes it distinctly different from the ICJ is that it's going after people, particularly leaders of countries or factions or groups that have perpetuated whole scale large abuses on many people. That's what they're going after. It's not a state filing a claim against a state, such as the ICJ. No, this is where they are going after large scale abusers, individuals, leaders of countries that have gone after large groups of people. So there's three basic mechanisms that the ICC can use to bring a case. First of all, one of the 123 member states can turn over an individual, and this is what we've seen mostly, particularly in Africa, where leaders that have finally been, after many, in some cases, decades of abuse and just running rampant power over their country and large scale abuses of large groups of people, then that state will go after them through the International Criminal Court. The ICC prosecutor can also bring a case if a crime is committed in a signatory state. So if you are a member system, then the case doesn't even have to be brought. The prosecutor can go after that individual if they feel like it's a large scale enough abuse, or if it fits their criteria, as long as it's in their signatory state. So that's another reason why the United States is not a member of this, so that not want the ICC to just come into our state. It's unlikely, of course, that the ICC would do that in a very stable democratic society such as the United States. But again, you can see this is what we're trying to do here, is understand it from both sides of the picture, not from the point of view of who's right, who's wrong, that sort of thing. We're looking at rational behavior as to why this or that does not happen. Now, the UN Security Council, of course, of which the United States is a member of, one of the permanent members, can bring proceedings against individuals in a non-signatory state. So as you can see right here, this would also make it unlikely for them to go after an individual in the United States, because the United States would potentially use their veto power to prevent that from happening in the Security Council. Now, here are the ICC cases with 4 convictions, 9 members in custody. So there are some things pending here. And when you look at this list, one thing that stands out fairly quickly that became noticeable fairly early on is that all of these cases, except for one, are in Africa. Now, that does not necessarily mean that there's a bias against Africa. It's just that the ICC and these states brought these cases to the ICC as well. But in most cases, the ICC feels like it wants to go after the largest, most offending perpetrators. And so the African states had several worth going after. So that's kind of where it got started. But over time, we started to see that Africa felt that there was a little bit of a bias, started to see a pushback there. Talk about that here in just a few minutes. Some examples of some cases. Thomas Lubanga from the Congo was the leader of a militia organization there that was convicted of war crimes. He's been sentenced and was there and sentenced, and 14 years. You may have heard of the Joseph Kony case in Uganda, arrested for war crimes, crimes against humanity. He was also recruiting child soldiers. He is still at large. And then Omar al-Bashir, who's the president of Sudan, who was recently deposed, was arrested for war crimes, crimes against humanity, and genocide. He is also at large. If he turns up in a country that is a member of ICC, he could potentially get arrested and brought to The Hague for trial. Now, the African Union, as I mentioned earlier, started to take offense to the number of cases that seemed to be targeting African states and started to object to what they felt like was a double standard. And the chairman of the AU, Robert Mugabe, quoted that we should start to distance ourselves from the ICC. But we did see that Burundi was the first state to actually withdraw from the ICC. They had ratified it and then were afraid of this double standard of going after African states, felt like it might not have been fair, and so they withdrew from the ICC. But we see that there's numerous preliminary investigations in many other states, and one that has come up that is potentially controversial is that the ICC authorized an investigation to go forward in Afghanistan, which would actually include looking at the activities of the U.S. military forces and the CIA there of potential human rights abuses. So the United States would certainly not be happy about that, but that is a potential that could be looked at in this investigation of Afghanistan. So we've talked about the opposition to the ICC from the United States point of view as to the major reasons as to why that is. After 9/11, America was very much unilateral in going after terrorists and did not want to be hampered in any way by international organizations, particularly international courts that might hinder the United States from going after terrorists in the way that it felt it needed to do. And they passed a bill in 2002 that literally authorized the president to use force to free any American held by the International Criminal Court. Have not had to do that. Unlikely that we will, but that gives you an idea of the sentiment of the United States, particularly in the aftermath of 9/11 with respect to international court. President Bush at that time also threatened to veto the UN peacekeeping ops unless the U.S. troops were exempted from ICC prosecution. And that's something that, regardless of the administration, would still want to maintain that exemption, perhaps maybe not threaten certain things. Also, post 9/11, we see that the United States negotiated about 100 bilateral treaties. That's with another country one on one, agreeing that neither party will surrender citizens to the ICC for prosecution. So we were actively resistant to International Criminal Court jurisdiction post 9/11. Now, it did lighten up a little bit, but the bottom line is the United States generally has, from their rational viewpoint, has more to lose than to gain by being a member of this because of our exposure. We're so spread out all over the world with soldiers and diplomats. Even President Obama supported, his administration supported the court in principle. Yes, we need to go after these bad actors, but he also retained, through an executive order, exclusive jurisdiction over our own personnel, and particularly in that executive order, that U.S. soldiers in Mali would not be at risk of prosecution by the International Criminal Court. Now, with the election of Donald Trump, it's turned even more adversarial. The Trump administration is taking more of an aggressive stance against the International Criminal Court and threatening to sanction judges. Now, this is the end of chapter 7. So be sure to take a look at the discussion forum following the lecture.